Just before I call the Honourable Philip Goff, I'd just like to advise the House that Grant Banfield, sitting here on my right, this will be his last day in the House today, as he is retiring. I call the Honourable Philip Goff.
I've been trumped by Grant, Mr. Speaker, but if I could personally wish Grant every best wish for the future and to thank him for his many years of service in this place. It's always sad to, I was going to say see an old face, I mean see a face that's been around for a long time, leave this establishment, but to you and to all of your fellow workers who make this Parliament function as it can, thank you very much for your dedication, your commitment and your service. Mr. Speaker, I was interested in Scott Simpson saying that he was going to take this home and read it over Christmas. Good luck. We'll give you a test on the 25th of January and see if you've thoroughly absorbed it. You know, it's been my habit in this House when talking about justice bills to describe the National Party's bills as lightweight political flim-flam. Well, I can't really sustain that particular argument on this piece of legislation. This is not a party political pamphlet, as so much of the national government's justice legislation has been. In fact, it's based on two very serious reports by the Law Commission, and my experience of the Law Commission is that they do their homework, they do their work well, and that we can be confident that the basis of this legislation will be sound. It is called, actually the debate on the short title will be fairly easy because unlike in other bills, I think we could agree that this is a Judicature Modernisation bill. It amends a bill passed in 1908. That's 105 years ago. So that's not to say that the Judicature Act has not been modified many times. It has been. But when you modify and you make ad hoc changes, you lose some of the coherence to the piece of legislation. So it is good to have this piece of legislation, and I'm so sad, Mr. Speaker, that I won't be on the Justice Committee and be required to read it page by page. Of course, Geoffrey Palmer would have already absorbed this before breakfast and would give you a scholarly account of what's in it. But I fear that some of my colleagues on the Justice Committee might be hard-pressed to treat it as it ought. It is 1,182 pages long. It could be called the Forestry Destruction Bill by its pure weight. Mr. Speaker, I want to say that while the bill has been, I'm sure, thoroughly drafted through the Law Commission, I have taken the time to read some of the regulatory impact statements, and the regulatory impact statements suggest that the Select Committee can't simply take this as a given, that it will have work to do. I'm looking, for example, at the regulatory impact statement on the Judicature Modernisation Bill, the second paper, and it has caveats on the work that the Ministry has been able to do on it. Limited consultation has been undertaken in relation to the options in this paper. We don't have reliable data to assist in considering a number of the proposals in this paper. We've not been able to model the operational impacts of the proposals. So, while the base and the work that the Law Commission has done is sound, the Ministry constantly complains through the regulatory impact statements that they have had to be rushed in the work that they've done on it. And indeed, if I look at one of the other regulatory impact statements on the Judicature Act and the consolidation of courts legislation, it says limited consultation has been taken in relation to the options which go further than the Commission's recommendations. So the work that the Ministry has done on this, by their own admission, hasn't been fully consulted, has been a bit rushed in the time available, and the Select Committee will therefore need to consider carefully the proposals in it. Mr. Speaker, I want to begin with my discussion on the substance of the bill on Part 5 of the bill. I'm taking it out of order because Part 5 of this bill stands out like a sore thumb. let me read what Part 5 does. It sets out legislation to enable and govern the use of electronic technology in court and tribunal proceedings, including all current paper-based requirements to be replaced with electronic processes. I read that, Mr. Speaker, with some degree of amazement, because last Friday the Minister of Courts stood up and said that an $18 million project on producing a paperless court that he had earlier boasted would mean that processing would be 70% faster and save 93,000 man-hours. This wonderful paperless court and the e-bench proposals that the government had invested $18 million on has been scrapped. This from the government that bought us the electronic wonder of NovoPay, and whose predecessor, the less than illustrious national government before we came to power, had bought us INSYS, which had wasted $100 million. Well, I've got some questions to ask of the hapless minister, who introduces a bill promising that this will be an electronic miracle, will save all of this money and all of these hours, and had to admit just days before this bill was introduced, that everything that the government had done on the e-bench had come to nothing, that the promises had not been delivered upon, and actually Part 5 of this bill is therefore meaningless and doesn't do what it promises to do. And I think in the course of debating this bill, and for Scott Simpson and the Court of the Select Committee looking at it, some hard questions have to be asked. How did the government stuff up converting the paper-based bench to an e-bench in a way that they spent millions of dollars and failed to deliver? I want to know how they got it wrong. I want to know how they intend to fix it. I want to know what the timetable is before Part 5 of this bill will have any meaning at all. And I want to know exactly what it costs the taxpayer in wasted funding, because this government once again stuffed up and failed to deliver on what it promised. So that certainly is a very controversial part of the bill. We were promised that the judges could open digital files in court, they could input changes including future appearance dates. Mr. Speaker, they could input bail conditions, and you and I sat in the court and watched the laborious way and the papers that appeared on the judge's bench. All of this was going to be digitalised, and it's come to nothing. What's the explanation for that? Can anybody on the national bench act as an apologist for their minister and say why the government stuffed this up? Because it is a serious matter. The taxpayer doesn't mind paying their taxes if the money is spent wisely, but when you spend $18 million, you make big promises and you fail to deliver, then this House deserves an explanation for why the government got it as badly wrong as it did. Well, that leaves me with 2 minutes to deal with the other 5 parts of the bill, Mr. Speaker. I want to say that there's some quite sound stuff in the rest of the bill. Part 1 repeals the Supreme Court Act, which isn't that old, 2003, and the Judicature Act of 1908, and it creates a senior courts bill. This brings together the High Court, the Court of Appeal and the Supreme Court under one system. I think that's sensible. It streamlines the appointment of non-permanent judges. It establishes a judicial panel under Clause 18 of the bill to hear certain types of commercial cases. These are incredibly complex and specialised cases, Mr. Speaker, and I think we should be developing the specialist expertise of judges and panels to deal with them properly. They can take a lot of time, they can be very expensive, they can be very complex, and I think that this is a move in the right direction. I note that there are more powers given in this part and in the second part to restrict vexatious civil litigants. If it is indeed vexatious, I'm quite relaxed about that, but we must also honour the right of people to have their time in court, and we shouldn't use that power lightly. Part 2 creates a unitary district court system, Mr Speaker. We've got 59 separately mandated district courts at the moment. This brings them together, and the Family Court and the Youth Court and the Disputes Tribunals will all become divisions of that court. It also increases the threshold of the claims that can be heard from $200,000 to $350,000, and I think that's sensible, Mr Speaker. I won't go into the details of the award of interest on money claims, but it is sensible to preserve the real value of those claims. We will support this bill, but the government must give an explanation of how they managed so monumentally to stuff up the digitalisation of the court system.
Mr Speaker.
Call Alfred Naro.